Hello, everybody. My name is Daniel Timins, and welcome to Creditor Protection and Asset Protection Trusts. This is the first in a two-part series regarding family assets and how you can keep them with your family. Just so everyone knows that I exist and who I am, I'm going to turn on my camera as well, so you know that this is not recorded unless you're watching this recording. Good morning, everybody. So, again, this is part one of a two-part series. Part two will be covering solely trusts and how we use trusts to help people protect their assets from creditors. This is all of the background as to what takes place with creditor protection and asset protection. There's also going to be aspects of investments and different types of accounts that you can set up to protect yourself as well. So, we'll start first and foremost with our disclaimer. And our disclaimer simply says this is attorney advertising. Once you see it, you can't unsee it. This is advertising, even though I also think it's pretty good information. This is our table of contents for today. First, we are going to be talking about different types of legal enforcement that precludes you from getting certain types of creditor and asset protection. We'll then talk about the different levels and different types of creditors that are involved that are trying to take your money from you. We'll talk then primarily today about protected income and assets. So section 3 is going to be the meat and bones, the heart of what today is all about. Section 4 will be a brief discussion about insurance plans and how those can help you to protect yourself from your creditors. And last but not least, we'll be talking about spousal protections and how your spouse may also be one of your worst creditors. So let's start with chapter number 1. This is going to be talking about limitations on your asset protection, laws or certain types of processes that will preclude you from getting asset protection. The first is bankruptcy. Now, bankruptcy actually is a great form of creditor protection. It's kind of the last, your last line in the sand, basically. You're about to lose the war and you're hoping to keep whatever you can from the victors. Just because you declare bankruptcy doesn't mean those last crops that you have in your civilization or those last houses are going to be totally protected from bankruptcy because bankruptcy has limitations as to creditor protection. Well, who are the creditors that even after bankruptcy can still bite their teeth into you? Well, the Internal Revenue Service, the IRS, you're going to find throughout today is a mega monster creditor. Just because you declare bankruptcy, if you still owe the IRS $200,000, it doesn't mean they're just going to go away necessarily. Child support and alimony, just because you declare bankruptcy doesn't mean you still don't have to pay for Timmy to go to school. Most student loans are also not exempted when you declare bankruptcy. In other words, the creditors can still come after you to pay those student loans with several caveats and limitations. And last but not least, any fines, crimes, or any type of repayment you have to make under certain circumstances is not protected from bankruptcy either, such as fraud or embezzlement. If I stole money from my employer and I declare bankruptcy 3 weeks later, doesn't mean my employer can't come back at me and try to collect those funds. Or, for example, you see the very last line here. If I bought a Bugatti, it was a luxury purchase, and 2 months later I say, I'm going to throw in the towel and I'm declaring bankruptcy, I got bad news. I can't keep that Bugatti. Right? Luxury purchases made right before the bankruptcy are going to be brought back in to your assets, and the creditors can come after them. The second most important slide of the day today, and I'll tell you we're in the first, is a fraudulent conveyance. This is when I transfer money to somebody or something else for free. I don't ask for anything in return, like a gift, and the creditor can take that money back from that person. And the important thing for fraudulent conveyances is this: if I transfer money to that person and I didn't even intend to defraud my creditors, that gift can still be pulled back. Here's an example. Hey, I tell my wife, Michelle, I'm going to give you $200,000, right? And then I'm going to get a loan from Tommy, and then I'm not going to pay Tommy back. Now, Michelle can say, great, I'll hold on to it. And they can take that money back from Michelle if I transfer the funds to her within the last 4 years. That's right. In New York in particular, the 4-year rule applies. Now, here's the other thing. What if my son Timmy is getting married and I say, Timmy, I'm going to give you $100,000 getting married. This is great. You're going to have a great wedding. I want you to start your family. And then lo and behold, I defraud someone 3 years later. The statute says that if I made a gift, it doesn't matter as to my actual intent. Whether I intended or didn't intend to defraud this creditor, they can potentially take that money back from Timmy if it's been within the last 4 years. So when I make a gift to someone, that money can get pulled back. Now, let's say I defrauded someone 7 years ago, right? And they didn't find out about it until today. Well, I transferred the money 4 years ago. So they're not going to be able to get at those funds. But for the fact that if they only have a chance to find out, in this instance, 7 years later, they still have an additional year to come after me at that time. So if the person that I decided to take money from, they didn't find out and I transferred all the money out of my name 7 years ago, they find out in year seven, they have until year eight to try to place a claim against me to get those funds back. So important to remember, a fraudulent conveyance is when you transfer money, you don't get anything in return. So it's a gift. And whether you intend to or not intend to defraud a person, they can come back at that money and try to reclaim it from the person you gave the money to. Now, the next aspect we're talking about today is the different types of creditors. Not all creditors are created equally. So the types of creditors we're most concerned with, I refer to them as your super creditors, right? These are the biggie baddies. These are like your Saurons, they're the ones that you just can't escape from. Well, I guess Sauron was defeated in Lord of the Rings, but the IRS is a really bad creditor, right? It's not going away. It doesn't matter how you try to protect your funds. The IRS is a super creditor, and like all super creditors, they're always going to have the ability, no matter what kind of sneaky tricks you try to do, to transfer your money to someone else. They're going to still be able to get at the money. Now, state governments are what I call super creditors light. For example, they can't go after your retirement plans and a few other types of assets. They have more powers than a lot of other types of creditors on this list, but they're not a true super creditor, state governments and their taxing agencies. Of course, here you have your divorced spouse or child support. You can't just say, nope, I don't have any money. They're going to look to see what you've tried to do. And even if you declare bankruptcy, like I said, they can still come after you. In different federal crimes, if I decide to throw a rock through the window of, I don't know, a federal courthouse, the federal courthouse, even if I'm broke, can still place a claim against me and they can get at my funds. Super creditors can always get at any type of funds. Next, there are statutory creditors. These are people who, under some type of law, have a specific right to get paid back. If my brother Andy ends up paying for my funeral expenses, and I said, yeah, Andy, I don't want you to get any money for anything. And in my will, I say, don't give any money to Andy. It doesn't matter. Andy is my first creditor because there's a public reason, there's a public policy. We don't want people's bodies rotting on the street. So there's certain types of creditors who absolutely get the first bite at the apple of any additional money you have. Student loans, like we said, are also statutory creditors. You can't declare bankruptcy, for example, and necessarily get rid of all your student loans, but there's several caveats. Secured creditors, these are creditors that have an asset underlying the debt. Great example, the mortgage on your home. If you pay 90% of your mortgage, right, or at least 90% of the principal of your house, and you stop paying your mortgage, the bank still has the ability to take your house. Now they'll sell your house, right? They're going to pay back the rest of the mortgage themselves that they're owed, and then they'll pay you the difference. So that's pretty good, but they have an asset underlying. So it's pretty difficult to confound secured creditors unless that property that they have and the debt puts it underwater. So, when people have a house that's worth less than the mortgage, they stop paying. The bank having at least the right to sell a home is something, but it doesn't mean they collect 100 cents on the dollar, but there's some type of collateral behind the debt. And the last are unsecured creditors. This is important because these are typically your lawsuits. Unless you have some type of personal guarantee, most lawsuits filed against you is an unsecured creditor. They're at the bottom of the list. Or credit card debts. If I owe credit card funds, they don't want to take back the shower head I just purchased for my apartment renovation, right? They want money. The medical debts that I receive, they don't want my used sutures. They want money, but they don't have any collateral. These are the weakest form of creditors. So unless you sign personal guarantees, lawsuits come after all of these creditors. So if you don't have any money, they don't get anything. Now, here's one way to confound some of these creditors when you die. Take notes. Number one, if I transfer property when I die using my will, I don't confound creditors for two reasons. Number one, my probate becomes public. When I die, my will is given to the local court that deals with my estate in New York. That's called the surrogates court. The process is public. So creditors can find out I died. They can look online. They can see, oh, Dan Timins died. Let's place a lien against his estate for assets or debts he owes us against his estate assets. Plus, my executor signs an oath, a written oath, sworn under oath, hand up on the Bible or whatever holy book you use, that says they are going to pay all estate debts. Probate is not a way to confound your creditors, but any other way you transfer your assets may be. We call that type of transfer operation of law, anything that transfers outside of your will. So if I have a revocable trust, or I have an account that names a beneficiary, or life insurance or retirement plans that name a beneficiary, or I have a deed on the home that is a transfer on death deed, doesn't go through probate, they are not exempt from creditors, but because these assets transfer privately outside of the court, probate is in the court. This is outside of the court. The good news is this: the creditors don't know necessarily that these assets exist or where they were transferred to. My trust is not a public document. My retirement plan, it's not hung out there in public like my will being probated. So these creditors' only course of action is to try to bring a litigation against the people they think received your assets. So if you have a spouse and kids, they may try to sue your spouse and say, well, you must be the beneficiary of Dan's estate. Well, maybe. But what if I don't have a spouse? What if I don't have kids? They say, well, Dan's nearest next of kin is his mom. And mom says, well, I didn't get any of Dan's assets. So they wasted money on a lawsuit. Then they say, well, maybe Dan's sister Jessica or Dan's brother Andy got the money. So they bring lawsuits against them. And they say, we didn't get any of the money. The creditors only type of action they can take is to take a chance. And every time they take a chance on paying a lawyer to try to bring a lawsuit against someone who's not a beneficiary of my estate, they lose. If you have a credit card debt and you die without a will, a lot of times the credit card company just kind of lets it go because it's too hard to find out who that beneficiary of your estate is under your retirement plan or your trust. So a tip, first of all, is life insurance and retirement plans have additional protections, but the real tip here, don't transfer your estate using your will. Create living trusts, set up beneficiaries on your accounts. Next, let's spend the majority of our time today talking about particular types of income and assets that are protected from creditors. And we start with the biggie baddie daddy, everyone's favorite source of income. It's around now. Who knows what will happen for your grandkids, but that's going to be their problem, apparently. Social Security is your most protected source of income. So, creditor protection from unsecured creditors. Remember, the IRS can always get at my money, right? But the state government can't get after my Social Security. Super creditors may be able to, but the lawsuit against me can't get after and can't place a lien on my Social Security. The credit cards can't go after my Social Security. So it's protected before Social Security is distributed to you and after it is distributed to you. So just because I have my $1,500 a month from Social Security going into my bank account doesn't mean the creditors can place a lien against it. Now, if I start mixing that around with sources of funds from something else, like, if I got a pension or I got a gift from someone else, now I've kind of sullied it all up. And so creditors could conceivably attach the Social Security because they can't tell what dollar is which between the gift that I got and the Social Security payment. Now, there are exceptions, like we said, alimony and child support. Your Social Security is not protected. Federal crimes, again, I am a terrorist. Good luck getting your Social Security. Federal taxes. Now, again, like I said, state taxes are exempt. State taxes are protected from, or I should say, your Social Security is protected from debts that you haven't paid to a state for state taxes. But for the federal government, the IRS, super creditor, they'll come at your Social Security. And student loans, they can take up to 15% of monthly payments from your Social Security. So like we said, student loans, pretty close to a super creditor. They're a statutory creditor. Again, my tip for Social Security, if you have creditor protection, place your money from Social Security in a different account from any type of other source of income or gift you're going to get. Because if you place that gift from, I don't know, your children or that bequest that you receive from a family member into your bank account that has the Social Security, you muck up that account and Social Security payments could be taken by your creditors. 529 plans. I'll start by saying 529 plans are a complex animal. They're great as far as attorneys are concerned because they have so many special rules. A lot of things with 529 plans regarding different types of contribution limits during lifetime maximums and creditor protection are based also on state law. Bankruptcy is and does have different state components. So, generally speaking, 529 plans do provide bankruptcy protection, but only for certain types of beneficiaries. So, if I give a 529 plan payment and the beneficiary is my child or my step grandchild, it's protected. But let's say I give it to my best friend Jay, and Jay and my best friend Gary both receive out of nowhere 529 plan contributions from me. They're not a child, they're not a step grandchild, etc., not protected from their creditors. Now, there's a time period requirement too. So basically, anything placed in after 2 years going to be protected. Again, there's some state law differentials, but this is the general rule that any payments that are made, there's a 720-day grace period before they're completely protected from bankruptcy. The big issue is this. If I set up a 529 plan, which I own, and I contribute money to the 529 plan, so I'm a donor, and I'm the beneficiary of the plan. I'm all three of these parties. Guess what? No creditor protection because it's just my alter ego. I control the account, I have legal title to it, and I contributed money to it. So 529 plans are not a get out of bankruptcy for free or get out of creditors for free type of plan. Next comes retirement plans. Your retirement plans are some of the most protected assets in the United States. Other than super creditors like the IRS, your soon to be ex spouse, your child support payments, retirement plans should be the focus of every creditor protection minded individual. Invest as much as you can in your retirement plans. And when I mean retirement plans, I mean qualified plans. So, for example, I should also say non qualified for you ERISA heads out there, but basically anything you contribute to your Roth or traditional IRA, basically totally protected. Your 401k plan, totally protected, except against your super creditors. Things like your rollover IRA from other plans, protected, and Section 457 plans for those of you who have them. There is some minimal protections for private annuities, and we'll be discussing that soon, but there are no protections for certain government employees. So here's an example. If I work for the state of New York right? And I have a New York retirement plan, I might not be protected from the state of New York trying to place a claim against me, right? So if I'm a federal government employee, I'm not worried about the state taking my money, but the federal government might be able to place a claim against my assets. So remember, if you are a state or a federal employee, there are certain caveats to your retirement plans, which would mean you would not be fully protected. Now, here are exclusions from creditor protection. We spoke about this already. You know, your IRA is not protected from a divorce, right? Your qualified domestic relations order at the time of your divorce, yeah, your ex-spouse can get at those assets before the divorce is over. Criminal fines, or if you stole money, same thing, kind of like a super creditor. Federal taxes, but again, protected for state taxes. The IRS can get at your retirement plan. And again, in many states, New York included, because we are doing a New York focused based program today, fraudulent conveyances into a retirement plan. I know I'm going to have problems with the creditor real soon. It's the IRS. Oh no. Or even if it's not the IRS, it's just someone angry because I hit them with the car. And so I throw a boatload of money into my retirement plan. Not protected. So keep that in mind. There are plenty of times a fraudulent conveyance can come back to bite you. Now, if I die and I leave my IRA to my spouse, my IRA becomes my spouse's IRA. But let's say I die and I leave the Daniel Timins IRA to Timmy Timins, and it becomes the Daniel Timins inherited IRA for the benefit of Timmy Timins. Sounds a little bit different than the Timmy Timmons IRA, right? Because it is. He never earned that money. It's my retirement plan going to him. The Supreme Court about 10 years ago said no creditor protection for Timmy under Dan's IRA and other creditors, such as, for example, if he hits someone with a car. Creditors can go after an inherited IRA. So, one of the practices that a lot of attorneys, including our firm, does specifically is this: we will have the funds be distributed instead of directly to the beneficiary to an accumulation see-through trust for the benefit of the beneficiary. That allows a disinterested trustee to protect the beneficiary from their creditors from your IRA plan to them. So you can get creditor protection for your family members if you take an additional step and make the retirement plan's beneficiary trust for the benefit of your children. That's its own course. We'll talk about that some other time. Next, life insurance. The important thing to understand about life insurance is there are three parties: the owner of the policy, the one who decides who the beneficiary is and typically pays for the policy; the insured individual, the person who, when they die, the funds get paid out; and the beneficiary. They can be the same three people, but you never name yourself as the beneficiary on an insurance policy, right? If you die, why are you leaving money to yourself? You're dead. So you tend to at least have some differentiations between these parties. Now, if I own a life insurance policy on my mother, right? And let's say my mother is the insured individual and she declares bankruptcy. The policy is mine. So the cash value in a permanent policy is protected and the death benefit proceeds are protected. So that's exempt against my mother, the insurer's creditors. And if I own a policy and my spouse has creditors, I am still protected. That life insurance proceeds cannot be taken by my spouse's creditors. Now, a beneficiary of the policy also gets protection. So if my son, Timmy Timmons, owes $50,000 to his credit card company, and I die, those funds are protected from the credit card company. Even if it's $10 million, American Express can't get their $50,000 lien placed against the life insurance proceeds. Now, the only one who could go after Timmy, of course, are the super creditors, right? The IRS, the biggie baddie guys, right? So, important things to move on to from there are non-qualified annuities. These are the annuities that when you go to a bank and you say, hey, I need some investment advice, they say, we got a great idea. Let's just put you in an annuity. Now, I was annuities marketing specialist, so I'm not going to poo-poo on annuities, but they are sometimes overprescribed. The point is this: if you have an individually issued annuity and you declare bankruptcy, there's a lot of different rules based on what state you declare the bankruptcy in. So in New York, there is annuity protection, but it's not absolute. So if I have $300,000 in an annuity policy and I say, hey, all the money in here is necessary to support me and my spouse and my family, the court may, and I say may, protect all of it or a portion of it, or they could say none of it, but they typically don't say that. Unless it was the part of a fraudulent conveyance, they're typically going to protect some of it. Now, if I'm going to, have $10 million in there, it's going to be hard for me to say it's absolutely necessary for me to protect all 10 million of this from my creditors, right? So the court's probably going to say no in that case. One thing I will say is qualified education expenses that are going to be paid by that annuity are protected. And if you are going to declare bankruptcy, you always have a $5,000 maximum that you can protect no matter what. Or I should say a minimum, as long as you contribute those funds within 6 months or longer of the bankruptcy. So if you're going to declare bankruptcy, you have Uncle Dan's permission to contribute $5,000 to a non-qualified annuity. Now, LLCs, limited liability companies, and limited partnerships protect you personally, but they do not protect your LLC assets. So here's an example. Let's say that I own a building and I rent the building out and there's a fire, and the tenants that I was renting out to sue the LLC that owns the building and they sue Dan personally. Well, they can win against the LLC. They could take the last penny's value of that real estate owned by the LLC, but they can't get at my personal assets, my home, etc. Now, let's flip the tables. I'm driving my car and I hit Rudy with my car. And Rudy is saying, hey, I'm suing you personally, Dan, because I own the car. My LLC doesn't own the car. And I'm going to also sue you for your interest in that LLC that you own. Well, my personal assets are protected from a lawsuit against the LLC, but this guy's bringing it a lawsuit against me personally, and he says you also own an LLC. He can take the assets owned by the LLC, or at least attempt to claim them in the lawsuit, because I own the LLC. I don't get protection of my personal assets from any personal lawsuit against me. My LLC is only protecting my personal assets from a lawsuit against the LLC. Now, the LLC must have a valid business purpose. I just can't put my investments in there like my brokerage account. I have to have some real type of business there. And of course, the assets must actually be owned by the LLC. A lot of people make that mistake. They set up an LLC and then they don't change the deed to be owned by the LLC or something else. Now, two states, Wyoming and Nevada, if you set up LLCs in those states, have what are called charging orders. If a creditor tries to sue your LLC in Wyoming and Nevada, they can only get the net income generated by that LLC. So that's great. If I have some type of business and it's an LLC that I've set up in Wyoming, they can only attach my assets, my income from that LLC, no assets. Now, if it's real estate outside of Nevada or Wyoming, it won't get that protection. Real estate is special, and we're going to talk about that in part 2 next week. We'll quickly talk about insurance policies. Don't forget, insurance protects you from your auto liability. You hit someone with a car, auto insurance. If you got a good policy, we'll cover that. Homeowners policy. If someone gets hurt in your home and sues you and tries to, go after your home, place lien against your home, your homeowner's policy protects your home. And let's say you want additional insurance. I hit someone with my car. I have $50,000 auto insurance liability. That's not a lot. I broke their legs in three different places, and they hurt their spleen and their arm, and and now they have back pain and everything else. I may want an umbrella policy that picks up after $50,000 and protects me from lawsuits. An umbrella policy is a great form of insurance and creditor protection. Why? Because it protects me from lawsuits. Now, because we have such a litigious society, premiums for umbrella policies have gone through the roof, right? So it's expensive. But I just want you to keep in mind that it's worth having an umbrella policy because, unlike an LLC, which again only protects your personal assets, and you could lose the building owned by the LLC, an umbrella policy can protect all of your assets because it's covering any type of liability, not just personal assets, but potentially lawsuits if you want against your LLC if you have an umbrella policy owned by the LLC. So again, this is why I say sometimes insurance may provide more protection than an LLC, because with an LLC, you're protecting at least, your personal assets. But if someone hurts themselves, if there's a fire in your building and they're your tenant, well, they could sue the LLC. You'll lose the building, right? You protect your personal assets, but you just lost $500,000 for your rental property. They sued and got the property, or what's left of it, the charred remains. You had an insurance policy, it protected you. It paid that person, and now you still have your real estate. Now, some people will create LLCs and they'll have an umbrella policy on the LLC, an umbrella policy on themselves. Look, there's nothing wrong with wearing, belts and suspenders. Perfectly okay. My point is that don't forget insurance in the greater context of creditor protection, which brings us to one special source of creditor protection, and at the same time, one of your worst potential creditors out there. The positive side, it's your loving spouse. The negative side, it's your angry spouse. Your spouse can protect you from creditors or be the worst one. First of all, your spouse is not liable for several of your debts unless they sign on for it. So again, when you're creating a contract with someone, you may not want to have your spouse sign it, because any asset you transfer to your spouse is protected from your creditors. I'm a surgeon. I take care of people and they sue me even when I don't do something wrong, but they have, I don't know, a little gas pain or something after I, replace their heart and their lungs. Well, I might want my house to be owned by my spouse instead of me because I know this person's going to sue me and my medical malpractice only covers me for so much. Okay, that's great. Your spouse can't be sued for your medical malpractice issues. Just keep in mind, when you transfer that home or the brokerage account, you as the transferor must surrender all rights and control of that asset being transferred. You can't say, well, I still get income, or I can really sell the house if I want to. So this is undesirable, of course, if you get divorced. Now your soon-to-be ex-spouse owns your home. And let's say you conspire with your spouse. Like I tell my wife, I'm going to take out a $50,000 debt from Tony. And guess what? I'm not going to pay him back. But before I do this, I'm going to give you my $200,000 so that way he can't sue you. Well, it sounds like a great idea, right? $50,000 for free. Here I come. And Tony's going to be out and he's going to be out in the cold, right? Well, that agreement between me and my wife is referred to as a constructive trust. It's like a quid pro quo, a bunch of winking of the eyes. That will defeat my spouse being able to be used as a creditor shield. And again, the court can still unwind a fraudulent conveyance. Same thing with Tony. Kind of, told him like, hey, I'm going to pay you back, but I'm really not going to pay you back. I'm transferring these funds to my wife. Now, there's another form of protection called tenants by the entirety. When my spouse and I, and this is in New York in particular, but there are other states too that allow greater tenants by the entirety. If we own real estate as spouse and spouse, husband and wife, or husband and husband, or wife and wife, you got to put a ring on it, right? If that's the case, and I have creditors against me, like in this case, I owe $100,000 in medical bills. If the hospital places a lien against our home and it's owned by Dan and Michelle as husband and wife, and I die first, the debtor spouse, the debt disappears, does a magic trick. Boop, Houdini totally escapes because we don't punish our spouse over their real estate and their home for mistakes that the debtor spouse made. So in New York, tenants buy the entireties when you jointly own property between two spouses. Now, it only applies to real estate owned jointly between two spouses, and it has to say that actually on the deed. And if the non debtor spouse, right, if the squeaky clean spouse dies first, trouble, because then they can place a lien against the house against me because I survived and I was the debtor. And if I get divorced, there's going to be big problems there because now it's no longer potentially owned by a married couple. So the tenants by the entirety disappears, right? So our tip here is the non-debtor spouse should transfer the home to the surviving debtor spouse using the irrevocable trust. Michelle is dying. And so she says, Dan, I don't want that creditor. I don't want, I don't know, T-Mobile to keep trying to get money from you. So I now own the home, Michelle. I'm going to leave it to you in an irrevocable trust that really leaves it for the benefit of our kids, but you can live there the rest of your life. That's how you can confound a creditor. Now, let's say that I'm getting divorced. So we're changing now from spouse as a helper to spouse as someone who's a little bit upset and trying to get their fair share of your assets. Now, once you've been served divorce papers, you cannot change your beneficiary forms or your will until a separation agreement is filed with the court. So once you know about the divorce, you can't really change your post-mortem documents. A tip: if you have a feeling you're about to get divorced, change your will and your beneficiary designation forms on your retirement plans and life insurance prior to being served that divorce. So when your spouse says, hey, I'm thinking of divorcing you, Dano, well, I'm just going to change my will and my beneficiary forms immediately. Now, what happens if I didn't do that? Now I'm stuck here in the middle of this marital dispute and then I get divorced. Well, then I have to do it immediately after the divorce, right? Now, there is legislation that says once a separation agreement is filed, my spouse can no longer claim against my estate. But you still want to update your documents anyway, even though it's considered under New York's EPTL 5 1.4, which I helped to draft for New York State. It nevertheless says this. It says that if you are divorced and you never updated your beneficiary forms, it's as though your wife or your husband, who's now your ex-wife or husband, has predeceased you. You should still change it. Now, here's the problem. I got blindsided. My spouse says, guess what? I'm hanging out and I decide I don't want to I don't want to keep being married to you, Dan, and serves me with divorce papers. By law, I can't change my beneficiary forms or my will. Now, some people who I would not claim to know change their will and beneficiary forms anyway during that time. Now, I'm not telling you to do that because that's technically illegal, but some people do it anyway. And last but not least, you cannot completely disinherit your spouse when you die, and your spouse cannot completely disinherit you. Now, getting divorced is different than actually dying happily with your spouse. So if my spouse and I are happy, but maybe we got into some arguments and then it gets worse, we say we're going to live apart, but it's cheaper to keep them, so she's not going to get divorced from me. And she then, when she's dying, changes her will and beneficiary forms and says, I'm leaving everything to my parents, nothing to you, Dan. Well, if we are married, I'm still entitled to my spouse's right of election. And this amount varies state to state. Sometimes it's as much as 50%. In New York, I'm entitled to a third of all of the property that my now deceased spouse had, even if she was given that property by somebody else. So if her grandmother dies and leaves my wife with $3 million and we didn't have a prenup or postnup, I'm going to get 1/3 of that $3 million when she dies, because dying happily is different than getting divorced before you die. So again, You can't completely disinherit your spouse. Now, the exceptions below are very clear. You can waive your right of election when you get married to another spouse. Hint, you don't want to do that unless you're the spouse that has a lot of money, in which case you want to convince your spouse to waive their right of election, at least typically. And then you can override that prenup or postnuptial agreement afterward. And then last but not least, two spouses can agree after you're married to say, I don't have any claim against your estate. You can waive your right of election, and your spouse can too, outside of a prenup or a postnuptial agreement. We've gone a little bit over, but I hope you got a lot out of today. Our next meeting will be specifically from simple to offshore trust, how to use trust to protect your assets. That's in 1 week from today at this time. I look forward to seeing you all then. Thanks again. My name is Daniel Timins. Have a blessed weekend.